This is passage number 3. Duration 6 minutes. Speed 100 words per minute. Dictation starts now. The present criminal appeal is directed against the judgment of acquittal passed by the learned Metropolitan Magistrate in a complaint filed under Section 138 of the Negotiable Instruments Act. The appellant and the respondent were known to each other for several years. It is the case of the complainant that the respondent approached him for a friendly loan of 5 lakh rupees for the purpose of his daughter's marriage. Considering the long-standing relationship, the complainant advanced the said amount in cash. To discharge this legal liability, the respondent issued a post-dated check drawn on a nationalized bank in favor of the complainant. Para. When the complainant presented the said check for encashment, it was returned unpaid by the bank with the remark funds insufficient. Thereafter, the complainant issued a statutory legal notice within the prescribed period calling upon the respondent to make the payment. Despite service of notice, the respondent failed to pay the amount, leading to the filing of the present complaint. During the trial, the complainant examined himself and produced the original check, written memo, and office copy of the legal notice. The learned magistrate, however, acquitted the respondent on the ground that the complainant failed to prove his financial capacity to lend such a large amount. Para. The learned counsel for the appellant vehemently argued that the trial court failed to appreciate the statutory presumptions available under Section 139 of the Act. Once the signature on the check is admitted, the court must presume that the check was issued for the discharge of a legal enforceable debt or liability. It is submitted that the burden of proof shifts to the accused to rebut this presumption by leading cogent evidence. The counsel further contended that the respondent did not even reply to the legal notice, which should be considered as an adverse inference against him. Para. In response, the learned counsel for the respondent submitted that the complainant is a retired person with no known source of income. It was argued that the complainant did not reflect the alleged loan in his income tax returns, which makes the entire transaction doubtful. The respondent's defense is that the check was lost and was misused by the complainant. It is a settled position that the accused only needs to raise a probable defense to rebut the presumption. He is not required to prove his innocence beyond reasonable doubt. The respondent maintains that the findings of the trial court are based on a correct appreciation of the facts. Para. We have carefully perused the evidence and the impugned judgment. The primary question is whether the complainant has established the existence of a legal enforceable debt. While it is true that the law presumes the existence of a debt, this presumption is rebutable. If the accused challenges the financial capacity of the complainant is duty bound to show the source of funds. In the present case, the complainant admitted in his cross examination that he had no savings and had borrowed the money from his relatives. However, none of those relatives were examined as witnesses to support this claim. Para. Furthermore, the transaction was entirely in cash, which is in violation of the provisions of the Income Tax Act. While such a violation may not automatically invalidate the debt, it certainly casts a shadow of doubt on the truthfulness of the complainant's story. The trial court has taken a possible view after evaluating the entire material on record. It is a settled principle that in an appeal against acquittal, the High Court should not interfere unless the judgment is perverse or based on a total misreading of evidence. We find no such infirmity in the present case. Consequently, the appeal fails and stands dismissed. No order as to cost. Over. Stop.